The Supreme Court, Chapter 4, Civics. In this chapter, we shall deal with the composition, the qualification of the judges, appointment and jurisdiction and functions, and enforcement of fundamental rights and writs. According to the Indian Constitution, there are three major parts or organs of government. We have already studied this earlier. They are the legislature, that is the law-making body, the executive, that is the one who implements the laws made by the legislature, and the third important organ stands to be the judiciary. Judiciary serves as a very important organ of government in various ways. In a federal governance system, the powers are distributed between center and the states, and so there is every chance of disputes among the two. Therefore, judiciary here tries to balance the powers and to protect the supremacy of the Constitution. It is an independent organ. In general, the type of judicial system that is adopted in India is single integrated system of courts. So, courts serve as institutions of delivering the justice, and all the courts in India are integrated. That is, physically they might be separated, but the judicial system followed in all the courts is integrated system. Now, both central and state have the highest court as Supreme Court at the apex. Supreme Court supervises and exercises control over functioning of the other lower courts, say the high courts and then the subordinate courts. Let us now look into the composition of the Supreme Court. The Supreme Court of India consists of a Chief Justice and 33 other judges. If the need arises, the Chief Justice feels that more judges are required for a particular case or matter, then by a law in the Parliament, it can prescribe a larger number of judges. That is, it can ask for, and a law has to be passed for it in the Parliament, where a larger number or the extension of the number of judges is prescribed. The Chief Justice is the senior most of the judges, and his appointment is based on the seniority. He is also known to be the first among the equals. That is, among all the equal judges, he holds the first position only on the basis of his seniority. Now let us see who can become a judge of Supreme Court, or what are the qualifications. Number 1, he or she must be a citizen of India, has been for at least 5 years a judge of a high court or of 2 or more such courts in succession, has been for at least 10 years of advocate of a high court or 2 or more such courts in succession. Finally, he or she must be a distinguished jurist in the opinion of the President. What does this distinguished jurist mean? Distinguished jurist is nothing but a person whom we can call as say an expert of law, or say one of the best of the professor who is quite experienced of any esteemed law university or an institution. So he or she can be brought in as for the Supreme Court judge. How is this appointment done? Now, the Supreme Court judges are appointed by the President in consultation with Union Council of Ministers, Chief Justice of India, and such other judges of Supreme or High Courts. That is, in case of appointment of a judge who is other than the Chief Justice, as we know, Chief Justice, as I said, is appointed on the basis of his seniority. So, other than the Chief Justice, for the appointment of any other judge, the Chief Justice can be consulted. Now, consultation would generally mean concurrence. Concurrence, that is an agreement. In case Chief Justice, who is usually the senior-most judge of the Supreme Court, is appointed. Now, when the Chief Justice is unable to perform the duties of his office by any reason, say of absence or otherwise, then the President may appoint another judge of the Supreme Court as the acting Chief Justice. The Chief Justice may appoint a judge of a High Court as an ad hoc. Judge of the Supreme Court is for a period as may be necessary. This is the term or tenure, what we say, can be for a period as per the necessity. And a judge of the Supreme Court shall hold office until he attains the age of 65 years. The appointment of an ad hoc judge of the Supreme Court are made with the consent of the President and after consultation with the Chief Justice of the High Court concerned. Now, these ad hoc judges are generally taken from the High Court. Therefore, the Chief Justice of the High Court is consulted with respect to this. Since Supreme Court is at the apex in the single judiciary system of India, it has got its own jurisdiction and the functions. When I say jurisdiction, this term needs to be more specified. Jurisdiction is the power that a court of law exercises in order to carry out judgment and enforce laws. I'll give you a simple example. Suppose I talk about the High Court and its jurisdiction, then I can say that the jurisdiction of High Court is the state. See, every state has got a High Court, and then Supreme Court at the apex has got its jurisdiction to the entire nation. That means cases limited to the state are restricted till the High Court, or the High Court restricts itself till within the state boundary. Okay, so we can say a span of area. This can also be told as span of area that a court can exercise its function, as I give you the example of High Court and jurisdiction of the Supreme Court too. But for Supreme Court, jurisdiction is unlimited, that is, it is the entire nation throughout India. Thus, it is also known to be the final interpreter. That is, once Supreme Court interprets and passes its decisions, no one can change it. It goes as final. So, next, jurisdiction and the function is to be discussed. Jurisdiction is again of different types. Here in the slide, you can just see original jurisdiction, appellate jurisdiction, advisory jurisdiction, and review jurisdiction. This original jurisdiction is something where the decisions come all the way directly to the Supreme Court. That is, the matter or the case has come to the Supreme Court directly, not from any of the lower courts. Supreme Court has to exercise its power for the original jurisdiction under some circumstances. These cases cannot be moved in any court other than the Supreme Court. These are generally those cases that cannot be moved in any court other than the Supreme Court. For example, we can take instances like, say, between the Government of India and one or more states, if there is a dispute, okay, between Government of India, that is central government, and any either one state or clubbing two states. So here High Court or District Court, they do not work. This case will directly be taken over to the Supreme Court. That is, it will listen to the case immediately or at the first instance. We can say it is the power of Supreme Court to hear and determine a dispute in the very first instance. So case begins from Supreme Court only. This will not arise or come from any lower court, and no other courts can even take it up because they come from the directly to the Supreme Court. Secondly, if there is a dispute between Government of India and any state or states on one side and one or more states again on the other side. So all in all, between the states or between the Government of India and the states and all, therefore Supreme Court has been given exclusive original jurisdiction in these sorts cases. Here there is some exception. This jurisdiction will not extend to a dispute which arises out of any agreement or a treaty which is in operation. This will not extend in certain other matters such as interstate water disputes, matters referred to the Finance Commission, etc., and adjustment of certain expenses and pensions between the Union and the states. So it has got its limitations, like these matters cannot be taken up to Supreme Court. Then we move on to Epilate jurisdiction. Epilate jurisdiction is something which means the meaning comes all the way from the word itself, meaning that the powers grant special leave to appeal against the judgment delivered by any court in the country. What is this? This says that through the form of appeal, cases can have a chance to reach the Supreme Court. That is, Supreme Court will give power to people to the fixed cases, or it will be it will give the power to those people if they are not satisfied by the decision given out by the lower courts. Let me cite an example again. Suppose there is a case which was taken up to the district court. The district court's judgment did not satisfy the person, and so this was then again brought up to High Court. Again in High Court, there is no satisfaction. So the person may appeal to the Supreme Court. Now, as the Supreme Court accepts and the appeal is forwarded to the person to bring the matter to Supreme Court or to the lower court to transfer the matter to Supreme Court, then it is known to be Epilate jurisdiction. Now, this is a court of appeal, which can be also said like this, and it means that it is a court which may change the decision. So what takes place here is, what happens on this appeal while this appeal is accepted, that is, when it comes to Supreme Court can either change decision that is given by the lower court, or it can reduce sentence passed by the lower courts, and it can extend to constitutional, civil and criminal cases. Okay. That means it can change the decision. Whatever the decision was given out by the lower court can be changed by the Supreme Court. Since that was not satisfying the person, that's the reason why it has come up to the Supreme Court. So that can be done, or the change can be done just by a reduction of the sentences that were passed by the lower courts, and This can extend to constitutional, civil, and criminal cases. Now, what does it mean by constitutional, civil, and criminal?